Hey, what's up, everybody? Carlo, better known as the DeFi Defense Lawyer, and I wanted to go live to talk about something that I think is incredibly important for the crypto sector. Many are not familiar with what is happening right now in a Manhattan courtroom, but I would submit that this criminal trial that's going on with Tornado Cash in the Southern District of New York has very, very broad implications for the crypto sector, for software coders and developers, for freedom of speech, and for the freedom of transaction, especially on blockchains. So I thought it was important, given that this case is coming to a close soon. The defense is currently putting on their defense case in the Roman Storm trial in a downtown federal courthouse in Manhattan. I wanted to kind of break down what this case is about, what the implications are here for the broader crypto sector and for free speech rights. So for those of you who are not familiar, Tornado Cash is a mixing software. It was a protocol that was created on the Ethereum blockchain by its co-founder, Roman Storm. Roman Storm has been a very, very vocal advocate about maintaining privacy on blockchains and the importance of having mixers so that people's on-chain activity, and let me kind of explain how this works for those who don't understand. Whenever you transact on a blockchain, it's fully transparent, meaning anyone can download and look at your wallet address and the transactions going in and out of your wallet address. This is different than the bank account. In a bank account, your private account information is not publicly displayed on a blockchain. So the concern is that if people know that you have high net worth holdings in crypto because they can see it through your wallet movements, then they're aware of what your assets are. And this presents privacy and security issues for people. So Tornado Cash was created as a means of mixing your cryptocurrency assets so that they would not easily be detectable on the blockchain. Basically, it is like putting a bunch of, for example, Ethereum that comes from one wallet into a dryer, metaphorically, and then tumbling that Ethereum with other holders' Ethereum. And then when it comes out of the dryer, it's coming out in a totally different wallet address, and it protects the anonymous nature of the original wallet that went in so that it's hard to trace it back to that wallet. Now, obviously, this type of software can be exploited just like any other kind of software, including instant messaging apps and virtually anything that you can put on your smartphone that communicates two-way or that provides any kind of anonymity or encrypted end-to-end service. Any of these types of software developments can be exploited by criminals for purposes of furthering money laundering and other illicit activities like violations of sanctions with countries that are prohibited from transacting with the United States. So yes, this is a hotly debated subject. How far should these anonymity, privacy preserving tools go? And where should the line be drawn when it comes to protecting against anti-money laundering and knowing the identity of the people that are moving money around on blockchains? So in the backdrop of all this, when Tornado Cash was dropped in 2019, it was widely used by people, both people who wanted to conceal their transactions from public view, wanted to preserve the decentralized nature of crypto and the freedom to transact and the right to privacy to transact. But it was also exploited by North Korean hackers, criminal organizations, and Tornado Cash got put on the OFAC sanction list. This was a bombshell of a development because it meant that anyone that was using Tornado Cash could be in violation of OFAC's very strict rules about transacting or interacting with wallets from sanctioned nations or entities. So this created concern. This then steamrolled into a full-blown criminal investigation, and an indictment was handed down in 2023 charging the founders of Tornado Cash with unlicensed money transmitter violations. And this is something that I have a particular degree of experience in because I being a criminal defense lawyer and having defended criminal cases now for well over 25 years, I've done a lot of federal work, and recently I've had an opportunity to defend crypto fraud cases involving the unlicensed money transmitter statute. So the indictment that was handed down in this case charged conspiracy to commit money laundering, which is taking illicit money, knowingly moving illicit money around to conceal its source. That's a serious offense under United States Code, carries a maximum punishment of up to 20 years imprisonment. The unlicensed money transmitter statute, and then violations of sanctions laws. So those are the three major allegations in the indictment. I'm going to circle back and talk about the money transmitter statute in particular, because this is one that has drawn a lot of legal commentary and a lot of legal battles with respect to this case, and also another case that's going on against the software protocol called Samurai Wallet. So indictment comes down, the criminal case moves forward, the defense files motions, one of which being a motion to dismiss the indictment with respect to the money transmitter statute. This is an important event in this case because many criminal defense lawyers and many First Amendment advocates and many lawyers who believe in the freedom to transact have felt that the money transmitter statute has recently been weaponized to go after software. In other words, if a software, according to the DOJ, in any way facilitates the transfer of money, then the person who runs that software protocol is potentially subject to prosecution under the money transmitter statute, which is 18 U.S.C. 1960. And this statute is almost like a strict liability crime, because in order to be convicted of this crime, the government has a pretty low bar. They need to establish that you operated a, quote, money transmitter business. Business has been very loosely defined, unfortunately, under the case law, and is a pretty broad umbrella. And that you operated this money transmitter business where you moved money around on behalf of other people without obtaining either a FinCEN, which is a federal license to be a money services or money transmitter business, or state law. Every state has some version of that FinCEN statute, which requires you to get a license to be in the business of being a money transmitter. I keep putting business in air quotes because that's a pretty big deal in this case. Is the anonymity preserving protocol that Tornado Cash created a business? And then is the money transmitter statute the appropriate vehicle to prosecute Tornado Cash? Because Tornado Cash, as we talked about, is an open source software. It's almost like prosecuting hammer manufacturers, because there's a possibility that hammers could be used to engage in violent crime, to break down doors and commit burglaries. So the fact that the hammer producers are aware that their product could be used to facilitate crime somehow makes them a co-conspirator in whatever crimes are done with that hammer. You've heard that saying, you know, looking for every nail, a hammer that's looking for every nail. This is kind of that sort of abuse of this statute, I would say. So there was a lot of pushback from the defense, and they argued that a motion to dismiss should be granted because Tornado Cash is a open source software and that it should not have been used in this respect by the DOJ to prosecute Tornado Cash for being an unlicensed money transmitter, because they don't even have to have a license for the service that they provided to people through their open source software. That's the first argument. The second is they were not facilitating or conspiring with anyone to move illicit funds. They simply provided an open source software. So this motion knocked around for a long time, didn't get anywhere in the courts, and didn't look like it was going to get anywhere until a couple of key events happened after the Trump administration took office. One is that we had a special memo that came down from the DOJ called the Blanche Memo, which specifically noted that prosecutors should not use the money transmitter statute to go after software protocols like Tornado Cash, for an example. This memo then sparked another round of motions by the Samurai Cash defense team, Samurai Wallet, I should say, and the Tornado Cash defense team. So now the argument is that the DOJ has actually got confirmation that they should not have been going after Tornado Cash in this way, or Samurai Wallet in this way. And then there was another stunning development that was revealed during the Samurai Wallet criminal case. It was uncovered that the prosecutors were aware of a memo from FinCEN basically advising that the 18 U.S.C. 1960 money transmitter statute should not be used to go after software providers, example, Tornado Cash. The defense argued that DOJ was aware of this. They were aware of this when these cases went to grand jury. They should never have presented these cases to grand jury. And if they did, this should have been revealed. It should have been revealed to the defense. They shouldn't have had to have found it on their own, so on and so forth. There's all kinds of arguments about what are called Brady violations. Is this exculpatory evidence that the prosecutors knew of and should have disclosed, and it prejudiced the defense? That's one argument. That this is not a good faith prosecution, that they should never have brought that count. In any event, now, fast forward, the arguments have been made, the motions have been filed, and Tornado Cash is in trial. And the trial has been an interesting circus. The government has had some stumbles along the way in proving their case. And they have since rested their case. And now it's the defense's team, the defense team's turn to put on their case. So we're all waiting to see what happens as far as whether the founder of Tornado Cash, Roman Storm, will testify. And a couple of other interesting developments that happened in this case that are worth talking about. Number one, yesterday it was reported that one of the defense witnesses from Chainalysis had advised the government that he was going to take the fifth due to concerns that any testimony that he offered in the trial could be used against him in a future criminal investigation or prosecution. This one is still unfolding, so we're kind of waiting to see what is exactly going on here. And then there was another development which was fascinating in this case. Dragonfly, which is an investor in Tornado Cash. There were some reports earlier in the week, and there were some court arguments being made in the trial that investors in Tornado Cash could potentially be targeted for criminal prosecution for their role in furthering the development of Tornado Cash through putting up money and investing in the software. That was a huge concern to people who were observing the trial. And one in particular was the Dragonfly partner, Hasib Karish. I hope I'm getting that right. Karishi. And initially it was reported that Mr. Karishi was reluctant to testify and that the DOJ had threatened prosecution if he in fact testified. Well, there was some clarification reported today, according to at least one media outlet, that the DOJ has since come forward and clarified that they are not prosecuting investors simply for funding the privacy tech, and that that witness was not under any sort of threat of prosecution. We'll see how this all plays out as the trial continues to unfold, but that nevertheless is an interesting development. So going back now to the money transmitter statute and why this one, of all the statutes that are being prosecuted in this case, is the most interesting and the one that I think will draw the most appellate activity if this case ends up in a criminal conviction, which would be devastating for software developers and for privacy advocates and for defenders of First Amendment free speech, because it could have a huge chilling effect for these software developers. Because what would happen here is if the DOJ successfully gets a conviction in this case against the Tornado Cash developers, then this would certainly have a chilling effect on other software developers who are considering launching anything privacy related, VPNs, anything like that, that could arguably make a case by the DOJ for criminal prosecution because people have taken that software and used it to commit crimes. You shouldn't criminalize code, is the bottom line of the Storm defense. Developers should not be prosecuted for what other people, third parties, do with their technology. We saw this recently in a overseas criminal investigation with respect to, and now the name, of course, is totally escaping me, one of the encrypted end-to-end messaging services that works with the Tron token. I'll get back to you on that one. I've drawn a complete blank. But in any event, it was widely reported the French government had put the founder on notice of Telegram. Thank you, Telegram. Telegram's founder, that their creation of this end-to-end encrypted software was being utilized by criminal enterprises to commit all manner of fraud and crime and hide their tracks because of the encrypted end-to-end protocol that is Telegram. So we're no stranger to this. Seeing a criminal trial going down in the United States, going after a software provider of open source software that anyone could download and use is troubling. Essentially, what's most troubling about it is, as I've said, the weaponization recently that we are seeing of the money transmitter statute to go after cryptocurrency fraud. I've seen it in my own experience go down, not from the side of the software developer, but I've seen the statute used to even prosecute domestic individuals who may be facilitating the movement of money, sometimes unknowingly, from overseas criminal organizations. You see, it works like this. The government has a hard time getting these overseas criminal organizations that operate in countries like Nigeria and so forth, where they operate these romance scams and these crypto investment scams, and they are constantly on the lookout for new victims, and they usually target elderly victims. They usually target elderly women with romance scams. They put up a fake profile picture. They entice the person to communicate and exchange direct messages. It then evolves into extorting them for money, taking money from them because of compromising conversations or pictures. Hey, it'd be a shame if this got back to your husband. You might want to just send us some money. Or it could be investment scams. Hey, got this amazing opportunity in this crypto investment scheme. You may want to get in on this. When in reality, there is no investment and you're just sending money via a blockchain to overseas fraudsters. Or they'll come up with some sob story, need money, need someone's in a country trapped, the government's holding them, need money to get them out, send money. And these people, because they have been roped into these romance scams, fall for it and start to send money. And it becomes embarrassing and they become isolated from their loved ones because they don't want to admit that after so many years of being, in the world and being savvy and having a career and now being retired, that they've now been ensnared in something as silly as a romance scam. But it happens. It's called pig butchering. They just keep extracting money from these poor people until there's no money left. Sometimes these result in very serious consequences. It was recently reported by CBS, and you can download it, that a daughter discovered her mother was deep in a romance scam with some unidentified person, and then mom went missing. Daughter started to unpack it all and discovered that mom was deep in a romance scam, didn't tell anybody out of shame and embarrassment, and then went missing. So these can have tragic consequences. But then what happens with these romance scams is they evolve into recruiting these people to act as money transmitters on behalf of these overseas criminal organizations. So they accumulate a bunch of money from all these scams domestically. It's all sitting in cash. They need to get it back overseas. Crypto presents a nice way for them to do that, but they got to get it converted to crypto. So what they'll do is they will use cryptocurrency, Bitcoin, or other blockchain cryptocurrencies to convert cash into crypto and send it overseas. What they'll do is they'll recruit people to be basically straw bank account holders. They will tell them, hey, you're going to receive money into your account in the form of wires, cash, cashier's checks, whatever. You're going to take that money and you're then going to forward it to someone who's going to convert it to Bitcoin and send it overseas. Those people sometimes are not in any way compensated for this. They're in the middle of something and over their head, don't even understand what they're doing. They definitely don't understand that they have to have a money transmitter license, because who knows that? I mean, this is such an obscure law. And the moment that they receive money from unknown people and then forward that money and have it converted to crypto and sent overseas, they're now exposed to prosecution under the unlicensed money transmitter statute. So instead of going after and arresting the people overseas, which they generally can't get to because of tough extradition laws, or they can't find these people, they're going after these intermediaries and they're prosecuting them. So I'm seeing the money transmitter statute be weaponized when it comes to crypto fraud in this respect, in addition to what's happening in the Tornado and the Samurai cases, which is going after the software that facilitates illicit activity using mixers for anonymity. So you take something that was launched for the purpose of privacy, but that has been abused. I mean, you could easily insert WhatsApp or Telegram or Signal and substitute it for Tornado Cash, because these are, again, end-to-end encrypted privacy tools that criminals could use to facilitate crime and money laundering. But you're not going after the criminals that are actually doing it. You're not going after the North American hackers or the North Korean hackers, or the overseas fraudsters, because you generally can't reach them. So you go after the domestic, you go after the software provider. And that's why Roman Storm is currently sitting in a Manhattan courtroom facing a criminal trial for money laundering, sanctions violations, and violation of the money transmitter statute. This has huge implications for the crypto sector. Cannot downplay how important this case is going to be, and the verdict in this case for the crypto sector broadly. Because if Storm is convicted and his partner is convicted in this trial, well, then this will basically set the precedent that anyone who creates a software protocol that could be used to further crime, and that they, according to the DOJ, do nothing to stop it, don't cooperate with investigators in revealing wallet addresses, and cooperate in helping to recover these funds, and are, as has been shown in this case, communicating about how this technology could be used for abuse, well, that might walk you into being a knowing co-conspirator in violating the money transmitter statute and money laundering, which carries serious consequences. So we had the bombshell revelation of the Blanche Memo. We had the FinCEN memo to DOJ, basically telling them that you shouldn't be using the money transmitter statute to go after software protocols. So the DOJ did a little pivot, and they kind of backed off of the software angle, that this was a software business, and they're more focused on using Tornado Cash to facilitate a violation of the money transmitter statute by moving illicit funds. So they've kind of been adjusting their strategy here in response to these bombshell developments, and they're continuing to press on. The defense has been fighting aggressively. Roman had to start a campaign to collect money to fund his defense, which I think the last time I saw was costing him somewhere upwards of $3.5 million to defend this case. It's a lot to go to trial in federal court, and it's a lot to defend a case like this, because it requires expert witnesses to break down and unpack what the government's trying to sell to the jury, and to refocus the jury on what's really going on. That costs money. It costs money to secure these experts, to pay them to review all this stuff, all the blockchain transactions. It costs money to the defense lawyers to file all these motions, to fight and argue for the unconstitutionality of what's happening here and the violations of due process. And all of that in a high-profile case in the Southern District of New York, in a Manhattan federal courthouse, comes with a big price tag. So Roman has had to seek out outside funding to help him with his defense. If you want to know more about Roman and his story, Eleanor Tarrant, who hosts Crypto America on X, did a podcast interview of Roman Storm, which I would encourage you to look for and listen to, because it'll give you a little more insight into what's going on. I'm going to continue to monitor this case, because it's interesting to me as a criminal defense lawyer who focuses not only on advising crypto startups, people who are interested in the stablecoin sector, but also having defended criminal cases, including crypto criminal fraud cases. I'm watching this very closely because I understand that if the government does successfully get a conviction here, of course it will be automatically appealed, which is going to cost more money and lots of money to defend this case on appeal. But it's going to raise all these legal arguments about just how far the government can go when targeting a software provider, and just how far the government can stretch the money transmitter statute to criminalize conduct like this. Because remember, like I said in the beginning, this is almost a strict liability crime. If they can prove that you were in the business of being a money transmitter, which they can simply say, you receiving money from a third party and sending it off to someone else makes you in the business of being a money transmitter. Even if you're not paid, I've heard that argument, even if you're not paid to do it, just because you maybe expected payment or whatever, that makes you a business, that you failed to get the proper license either through FinCEN or a state license, which most people wouldn't even know that they are doing anything illegal to begin with, and that they would need a money transmitter license, because that's not why all of this was created. This wasn't created to go after these intermediaries who are basically just being duped into using their bank accounts to move money around for other people. But nevertheless, that's where we're at. So this is all going to be hashed out on appeal if Roman is convicted. Also, the far-reaching consequence is if Roman is convicted, then developers of software that touch on any level of anonymity or blockchain technology that could be used in a way that could facilitate crime, and now, depending upon how this all plays out with these investors in these software protocols, whether they may end up somehow being targets because they invested in these software protocols, whether this open source software could be prosecuted criminally, meaning weaponizing criminal statutes to go after software providers. This goes against the First Amendment, freedom of speech. This goes against the freedom to transact. This goes against privacy. This goes against DeFi and decentralized finance. And this presents a significant existential threat to crypto, to the freedom to transact, and to privacy. And that's why I feel, in closing, that this case is probably the most important criminal case going on right now, the most important criminal trial for crypto, because the consequences of what happens in this Manhattan courtroom can have very devastating and far-reaching effects, chilling effects on what people do with open source software. So if you enjoyed this, if you found this to be informative and of value to you, please give a like to my account. I'm on TikTok at the DeFi Defense Lawyer. I'm on X, the DeFi Defender. I've got a podcast. I've got a link tree with all my links. My website is cryptocouncil.io. If you want to know more about me, learn more about cryptocurrencies, stablecoins, etc., I'm happy to keep putting out this content to educate the community about important things that are coming, like what I've previously talked about, the Genius Act and what that's going to do for consumers and businesses, and the ability to break the bank's stronghold on moving money at the speed of banks and empowering consumers to move money at the speed of the internet. I put out a great deal of content. Over the last 4 years, I've probably covered every major development in the cryptocurrency sector when it comes to legal developments, and I'll continue to do that. So if this was of value to you, definitely give my accounts a follow. Subscribe to my newsletter on Substack, the DeFi Defender. Give this a like and a share if you think it will be of value, because I think it's important to spread the word here of what is going on when it comes to software providers and prosecuting them for simply providing open source software that others may use to facilitate crime. Thank you everyone for tuning into this. I will get this up on YouTube as well. And even though I'm going live, I will also get this up on TikTok and on X. And I'll keep bringing you more of this content. All right, I'm going to shut it down, and I hope everyone has a wonderful day.